Welcome everyone. I'm Russell Alexander. I've been practicing law for over 20 years with the team here at Russell Alexander Collaborative Family Lawyers. You can learn more about case law and how our office is dealing with COVID-19 and divorce at our Divorce Information Center at russellalexander.com. Without further ado, let's get into today's topic, and it's a big one. 10 things you should know about Ontario child support in 2021. Number 1, how COVID-19 affects child support in Ontario. The pandemic has wiped out many industries and parents have lost their jobs. A loss of employment could cause a change to the quantum of child support that the support payer is usually required to pay. Parents need to be reasonable and accommodate requests to adjust child support in light of the economic impact of the pandemic. If you are seeking to either change child support obligations, it is important that you provide written notice and supporting documentation to the other parent. FRO, or the Family Responsibility Office, will only enforce court orders or written agreements. If the other parent does not agree to change child support, then you may need to go to court to ask the judge for a new order. Child support is ordinarily paid based on the parent's current income. But if you worked for part of the year and recently lost your job, your estimated annual income for the entire year will be taken into account when adjusting child support. Number 2, child support. All dependent children have a legal right to be financially supported by their parents. When parents live together with their children, they support the children together. Parents who do not live together often have an agreement or an arrangement in place in which a child lives most of the time with one parent. That parent is said to have custody of the child, although that language is recently changing with the Divorce Act. This arrangement can be written into a separation agreement or court order, sometimes called legal custody, or may occur without a written agreement or court order, sometimes called de facto custody. Either way, the parent with custody has the main responsibility for day-to-day care of the child and has most of the ordinary expenses of raising the child. The other parent should help with those expenses by paying money to the parent with custody. This is called child support. You can learn more at various resources that we've posted, including top 20 COVID-19 questions about Ontario custody and access and child support obligations during the pandemic, common questions about child support in Ontario, an introduction to child support and custody, child custody, how decisions are made, child support 101, and more resources that we're going to have linked below in the comment box. Number 3, parents and guardians. The parent or guardian can be the birth mother or father, an adoptive parent or step-parent who has been married to someone with children, or who has lived as a couple with someone with children, and who has shown an intention to treat those children as members of his or her own family. We've again linked more resources to this particular topic in the links below. COVID-19 vaccines for kids, which parents get to decide, outdoor access ordered for one dad because of the pandemic, court ruling on remote versus in-person learning for children of 2 teachers, a mother who worries about COVID-19 and the blocking of a cottage week with the child, Ontario custody and access, who's entitled to support, who's considered a parent, when non-parents of a custody child wants access, and more. Look for the links below. Number 4, child support and who pays it. Child support is the legal responsibility of parents or guardians to provide financial support for all dependent children. When there is an arrangement with a child living primarily with one of the parents or guardians, they are assumed to have custody of that child and bear the day-to-day expenses of raising them. However, they may be entitled to receive child support from the other parent. This entitlement to child support may even continue even if the custodial parent remarries or starts to live with somebody else. The amount of child support is usually set according to the child support guidelines. More than one parent can have a legal duty to pay child support for the same child. For example, if a child with custody separates from their marriage or common law spouse who is not the child's birth parent, both the child's birth parent and the step parent may have a legal obligation to support that same child. Again, we're linking more information below, such as who pays child support in Ontario, top 4 questions about common law relationships, whether an agreement can be changed, can you be forced to pay the appropriate child support, and more. Number 5, when to apply for child support. Applying for child support is usually done right after a separation or when applying for a divorce, and can be applied for at any time thereafter. It is usually best to deal with all these matters as early as possible when sorting out custody of the children. In the beginning, parents and guardians may feel they don't want or need the support, but as time goes on, the expense of raising children increases. The need may arise, which time they can apply, even after divorce or settlement of the matters arising from the separation have been dealt with. Under some circumstances, the court awarded custody and support while the parents or guardians are living separately under one roof, but the court usually doesn't make an order until one of the parents or guardians have physically moved out. If the social and emotional relationship between the step-parent and the child have been disbanded for a lengthy period of time, it is less likely the court would order the step-parent to pay child support. Again, we are including several links below and in our blog where you can learn more about child support and when to apply when the guidelines apply. If you're enjoying this video and find it helpful, you can give it a thumbs up or leave a comment for us in the comment box below. Number 6, we're halfway through. When does child support end? Child support must be paid if the child is still dependent and they are under 18 years of age. However, the following are circumstances and criteria that can terminate the responsibility of paying child support. For example, the child is married. They are 16 years of age or older and have voluntarily left parental control. There are situations where even if the child turned 18 years of age, they are still considered a dependent. For instance, any situation where the child is unable to support themselves due to any of the following circumstances. They have a disability or illness. They are attending school full-time. In a situation where the child is 18 years of age or older and living away from home because they are attending school, child support may have to be paid if the child's primary resident with the parent with custody. The circumstance usually requires child support to be paid until the child is 22 or receives a post-secondary degree or diploma. In some of these situations, a judge can order child support to continue past this point. If a judge decides child support must be paid past the age of 18, they will allow into consideration how much the child's earning or income before determining the amount of child support to be paid. Again, we're listing a bunch of links below where you can learn more about the specific topics, such as does the age of the child affect child support? How long does child support continue? 5 things to know about support for children over the age of majority. Number 7 of our 10 items, how child support is paid. How child support is paid and how much is paid is determined with a support agreement. There are different ways parents can obtain a support agreement, which we are detailed below. In a situation where the parents can work together to form a support agreement, it is encouraged that they look at the child support guidelines to find out the amount the judge would likely order. The paying parent will have to give complete and true information about their income. It's suggested that one parent should have a lawyer put into an agreement or in writing that the other parent can give to a different lawyer to review before signing it. This way, both parents will know the agreement is what they intended to say, excuse me, while also protecting their rights and the rights of their children's rights. If the parents need help working out a support agreement, then they can see a mediator who will help them come to an agreement they can both accept. The mediator is an unbiased party that usually will not offer legal advice. In this situation, it is still recommended that the agreement is reviewed by both parents' independent lawyers before signing and filing with the court. Excuse me, if the parents cannot agree on a support agreement, then both parents should hire their own lawyer. These lawyers can then attempt to negotiate support terms that both parents can agree on. If no agreement can be reached, then they will go to court and ask a judge to determine support. Is another option that's open. The judge will make a court order that states how much child support is required to be paid. Again, we're listing more links and more information that you can find out about this subject below, including how to arrange for child support to be paid, how base child support is calculated, and how child support payments are taxed. Number 8, access when child support is not paid. Even if child support is not being paid, a parent should not keep the child from seeing the other parent. It is assumed that it is generally good for a child to have a relationship with both parents. Keeping the child from seeing the other parent is considered punishing the child, and the law will not punish the child due to their parents' failure to pay child support. Parents who do not have a custody agreement or custody are usually given access to the child so they can spend time together and maintain their relationship. These terms are being updated by the Divorce Act. The only way access can be refused or limited if the parent's behavior is likely to cause harm to a child or harm the child in any way. The court will not refuse access because the parent fails to pay child support, and the parent with custody should not refuse access for this reason either. There are ways to obtain child support from a non-paying parent without refusing access. Again, we're listing resources where you can learn more, including a deadbeat dad who was jailed for 4.5 years for failing to pay $250,000 in child support. A topic about keeping the children away if support's not paid, child support and access rights in Ontario, and more. So look for our links below. We've got lots of resources for you. Number 9, enforcement of child support in Ontario. Enforcement in Ontario is done through a provincial government office called the Family Responsibility Office, or FRO. The court automatically files all support orders made after July 1, 1987 with FRO. The parent who has to pay support is told to make all support payments to FRO. When FRO receives the payment, it sends a check or transfer to the parent with custody, or deposits the money directly into the parent's bank account. It only does this after it's received the money from the paying parent. If a payment is missed, the FRO takes action to enforce the order or agreement. To do this, the FRO needs as much up-to-date information about the paying parent as possible. This information about the paying parent goes on a support deduction information form, which is available at the court. This form is given to FRO along with the support order or agreement. It's important to update this form whenever information changes. FRO usually uses different ways to get payments that are owed. For instance, it can get payments directly from a parent who's supposed to pay child support, have payments automatically deducted from the parent's wages or other income, which includes things like sales commissions, employment insurance, workers' compensation, income tax refunds, severance pay, and pensions. It can register a charge or a lien against the personal or real property of the parent who fails to pay support he or she owes. It can garnish or take money from a bank account of the parent who fails to pay support. It can garnish up to 50% of a joint account that he or she has with someone else. It can make an order against another person who is helping a parent hide or shelter income or assets that should go towards support. FRO can put more pressure on parents who do not make their support payments by suspending their driver's licenses, reporting them to the credit bureau so it would be difficult for them to get loans, or canceling their passports, making it difficult for them to travel. Once an order or agreement is filed with the FRO and the other parent is not responsible for any actions taken to enforce it. Sometimes parents receiving support withdraw from FRO because it's easier for them to receive payments directly from the other parent. But if problems arise later, and if they want to refile with FRO, they might have to pay a fee to do this. Again, we are listing a bunch of resources in the link below and in our blog in terms of learning more. We're on our 10th point here, how to reduce child support. Parents who have an obligation to pay support should also know that FRO cannot change the amount that the order or agreement says they have to pay. They think that the change in their financial situation justifies a reduction in the amount of support they should pay. They must get a new agreement or go to court to get the support order changed. We're providing additional links on this particular topic, including varying child support, how long you should wait to vary child support, and more. So some final thoughts. Divorce can be an arduous journey, especially when we are in the midst of a global pandemic. This past year has brought new challenges to the family landscape. We aim to provide our community with helpful resources and support them in navigating family law matters. We have bi-weekly divorce seminars that you can learn more about divorcing during the pandemic and how to navigate separation and support issues during the pandemic and what to expect going forward. We offer other resources such as ebooks, videos, free online articles, and more. Look for links in the show notes below. To learn more about this topic, you can read our blog and watch more YouTube videos that we have. Please leave your thoughts and questions in the comment box below. If you liked this video and found it helpful, please give us a thumbs up to let us know. You can subscribe to our channel and hit the bell icon to get notification every time we upload a new video. Thank you for watching.